Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you the Roadside Chat from the studio. This question, we pulled up here, comes from an officer in California, and he basically asks, if I see plain view evidence in a past the threshold of a motel room. So let's say I'm doing a knock and talk at a motel, and I look in the motel and I can see plain view evidence. Can I go in there and grab it under plain view? No. The answer is no. The reason why is that, first of all, plain view is right to be, right to see, hear, and smell. Right to be. Is the cop lawfully present? 100%. Doing a knock and talk at a motel, in the hallway, got right to be there? Good. Did the cop use his God-given senses to see the evidence? Right? Didn't use any high sophisticated equipment, drones and so forth, things that implicate other issues. No, the cop is looking inside the motel door, and so forth. So right to be, right to see, hear, and smell. The problem is plain view doesn't allow an additional constitutional entry. So if we're already in the motel for some lawful reason, we're evicting people, we are consent to enter, right? We have an arrest warrant, and we're in the hotel and so forth, and we see plain view evidence, then go for it. Go ahead and grab it and go. But the problem here is the officer is outside, so the plain view exception will not allow the officer to enter the room. You would need another reason to do that. Consent. Hey, look, I see the evidence right there. If you want me to go get a warrant, I will, but I'm going to exclude you from the room. And, otherwise, this is a citable offense. You can do something like that. That's not coercion. You can give people options. You can, if the person sees you looking at the evidence and then closes the door on you, and it's a type of evidence that can be easily destroyed. It's not like a piano, and it can be flushed down the toilet by the time you get a warrant. Then we have eminent destruction of evidence. But that's kind of what we're doing here. I did find the case, recently that where the cops were walking past an open garage and saw plain view evidence, went into the garage and seized it. And there the court upheld it. But I'm telling you, I think the court's dead wrong on that. They held that since the person left the garage door open, they had no reasonable expectation of privacy in the item. Well, they're correct about that. But what they're wrong about, in my humble opinion, is that they still have an expectation of privacy of where the contraband is. To me, it's no different than walking past a window at an apartment, looking in the apartment window from plain view, right? You're lawfully present, and looking into the window and seeing stolen property or drugs or whatever. Do they have a privacy interest in those items? No, they showed it to the whole world. But does that mean you can go in there and seize it? Absolutely not. The same thing if they left the door open. It doesn't mean you can just walk right into somebody's home. And I know the garage is obviously not as private as a living room, but usually garages are attached to houses. And if that's attached to the house, to me, it's off limits. But there you go. Reasonable minds can differ, my friends. And that's why we have these classes. Guys, that's what I have for you today. Stay safe out there, right? The family, the Blue to Gold family loves you and loves everything that you're doing for our communities. You're keeping us safe, and especially under trying times. If you like what I'm doing here, 3 things. Hit like or comment, hit subscribe, share with your friends. All right? Until next time, my friends, stay safe.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.